you may begin.
Thank you. Good afternoon, everyone, and welcome to the Institute for Ethics and Government's Advanced Practitioner Series. As you all hopefully know by now, we offer the series every month on the third Thursday of each month. And today we are particularly delighted that we have two speakers from federal government agencies to join us today. Sean Croston will be joining us, as well as Jeremy Suttenberg, and I will introduce them more formally in a moment, but we have a few announcements we'd like to get through first, and then I will introduce Jeremy and Sean and turn the presentation over to them. Next Thursday, we are going to be sponsoring another 1-hour session where we're going to be discussing the Institute for Ethics and Government's year in review and look ahead. So in effect, we're going to be sort of reviewing what we've offered, the offerings we've had over the last fiscal year, and be discussing a little bit what our plans are for the next fiscal year. And we are at some point going to be wanting to solicit your input on what you'd like to see us provide to the community in the next fiscal year. So please do tune in next Thursday at noon. We're going to be discussing that next Thursday. So next month is going to be gift month. Effectively, we are going to be offering another MOOC on widely attended gathering determinations. Our fundamental series is going to be dealing with a variety of gift issues, and then our advanced practitioner workshop series next month is going to focus on distinguishing when you can use the widely attended gathering exception and when you should use the 1353 authorities for gifts from non-federal sources. One other thing we're going to be doing next month, we're going to be having a couple of teleconferences to give you some summit previews, to give you a look ahead to what we will be offering at the summit in September. So keep your eyes posted for announcements about that. And so now I'd like to turn the presentation over to Sean and Jeremy. I would just want to thank them both for coming here today. They're going to be talking to us about the panoply of authorities that can apply when government employees basically are bringing sort of their personal interests and activities into the workplace. And they'll be discussing some scenarios and what sort of authorities could potentially apply to those scenarios. Some of them are ethics authorities, many of them are not. So Sean is a senior attorney and deputy ethics official at the Federal Reserve Board, and he's been there since 2014. Previously, he was at the Nuclear Regulatory Commission and also served as an attorney and ethics official at the Federal Trade Commission. Sean got his BA from the University of Rochester and his JD from William & Mary School of Law. So we're delighted to have Sean here. And his cohort today, his partner in crime, is Jeremy Suttenberg. Jeremy is an attorney and a deputy ethics official at the Nuclear Regulatory Commission, and he's been there since 2008. Jeremy earned his BA from Washington University in St. Louis, and he got his JD from the George Washington University Law School. So, gentlemen, welcome, and I turn the program over to you.
Okay, thanks for the introduction, Cheryl. We're happy to be here, and we can just get a few things started here with our slides. First, of course, we have the obligatory disclaimer. Even though we may be speaking in our official capacities as ethics officials, we want to follow all of the regulations and just be extra cautious. So, of course, our opinions are our own. We're not necessarily speaking for the Federal Reserve Board in my case, or
for the Nuclear Regulatory Commission in my case.
So, now that that's out of the way.
So now that that's out of the way, what we're going to be discussing today, as Cheryl was talking about, were people who are trying to promote outside interests while they're on official time at work. And as deputy agency ethics officials, we get a variety of questions that involve people who want to promote stuff while they're at work, people who want to do fundraising, or people who ask about certain political activities that maybe they want to work on and support. And so there's a variety of kind of rules and laws that apply to these scenarios. They're not all in one place, and so we thought that it would be a very good idea to go through some of these scenarios, discuss some of the problems and questions that they raise, and then discuss some of the rules and laws that would apply to these scenarios.
And if you look at the other PowerPoint slides, you can actually see there's actually a list of a number of these authorities, which might be good to use as a reference when we're talking about these slides and also for future use. And we actually could have added even more authorities. I mean, there's lots of things. There's Title 18, criminal prohibitions on misusing franked envelopes and things like that, and conversion of agency property. But for our purposes, I think we've got a pretty long list. As we mentioned, some of these are ethics laws, and some of them are appropriations rules, fair housing laws, and you're talking about other things. It's quite a variety that can come into play with the various scenarios raised by agency employees. So,
and I would add that the kind of common ethics criminal statutes that most people think of, 18 U.S.C. 205, the conflict of interest statutes, and then the acting as an agent statute, those probably aren't going to be implicated by the scenarios that we're going to be discussing here, because for one, the United States isn't usually going to have an interest in you trying to sell Girl Scout cookies or something like that while you're on federal property. And these also are going to be stuff that relates to your personal work, your personal capacity. They're not going to be official work, so you're not going to get into then the conflict of interests that you would have to do if you were looking under those statutes. So we're really discussing not the classic ethics criminal conflict of interest statutes. We're going to be discussing, as Sean was mentioning, a variety of other different laws and other sources of these regulations.
okay, so we have our first scenario here that comes up all the time. I think a lot of agencies have child care centers that are located on site. A lot of GSA buildings have them, for example. Not all of them, but for those agencies that do have these on-site child care centers, I think the general rule is that they're supposed to be organized as nonprofit boards that operate these facilities, and they often want to raise funds. In fact, they're supposed to be involved in some fundraising, usually to raise money for tuition scholarships for kids of lower level agency employees and so forth. And so I think if you're at one of these agencies, you'll often find yourselves confronted with these questions where agency employees approach you and they are affiliated with the child care center board, and they ask you whether it's okay to raise funds for their child care center for these tuition scholarships and things like that. And there's lots of different ways they want to raise funds, and so this scenario just presents one of them.
Yeah, and so basically the general OPM rule is that you can only do fundraising during the CFC, and you can only fundraise if it's part of that CFC period. There is an exclusion in the OPM regulations for what they would call, I guess, let's see, solicitations conducted by organizations composed of civilian employees among their own members for the benefit of that own group. And so OPM has said in a memorandum that this exception basically authorizes child care centers in federal facilities to conduct fundraising as long as they don't do it during the CFC period. So they can't compete with the CFC and try to do fundraising during that time, but if they do fundraising in, I guess, May or April or June, then that's permissible. And so that kind of takes care of the OPM fundraising rule. Then you get into the GSA rules, which do generally prohibit commercial fundraising and other kinds of commercial activities on federal property. But there is an exception in the GSA regulations specifically for daycare centers, which means that a daycare center can actually do commercial activities while on federal property. They can hold a bake sale. Those are perfectly permissible. They can try to sell other things that maybe people would be interested in buying to benefit the daycare center.
And they can also solicit funds under the GSA rules. They can solicit funds in the leased areas, so they can always just ask people who are coming to the daycare center if they can donate, if they've got some donation box or something like that. They can have collections there. But I think some of the more difficult questions come when they want to solicit outside of the daycare center, for example, in the hallway or in the lobby or something like that, from employees passing by. Like we mentioned, there is a commercial activities exception, so bake sales and things like that are usually going to be okay. But the more difficult questions come from just when it's cash solicitations, especially during the CFC period, but also I think that OPM and GSA legal opinions suggest that these solicitations should not reflect negatively on the agency. So as with many things in ethics, appearances matter, and so you want to be careful if you're approving any of these solicitations, how they do it, basically. It needs to look right. So, okay.
Okay, so the next scenario that we're going to be describing is the retirement scenario, and this happens all the time at the NRC. I'm sure it happens at your agency as well. The fact pattern here would involve an agency employee who is retiring, and then that employee is going to have a retirement party or some other kind of event. And then that employee wants to say, in lieu of a gift or in lieu of money for food at the party, please give a donation to a preferred charity, or please give some other kind of donation to either maybe even a political campaign or something like that.
You never know what employees.
You don't know what employees are going to come up with and what they're going to ask, and so this raises a host of potential pitfalls and problems.
Sure. So there's lots of different legal authorities you'd want to consult in these situations. First, of course, I guess you can always look at the criminal laws, but in these cases, you've got Title 18 U.S. Code, you got Section 208, Section 205, but in most cases, those won't apply because here it's not really like the employee is personally and substantially participating in their official capacity in any government matter, because again, I think a solicitation for a retirement party gift is more of a personal matter than an official matter. So you always want to think about those criminal laws when you start off, but that they're not really going to be implicated in this type of situation. And also, when you're fundraising for a charity, you're generally not doing it as an authorized agent, so you're not representing them for like Section 205 purposes. So I don't really think you need to worry about the criminal laws in this case. But there are a number of other regulations that you still need to consider. For example, you've got the OPM CFC fundraising rules in 5 CFR Part 950 that may come into play if they're fundraising for some nonprofit charitable group. And then there's also the GSA soliciting rules if they're in federal property and they're soliciting for some sort of a nonprofit. And so you want to consider those also. And
there's also the OGE fundraising rule, which prohibits federal employees from basically soliciting their subordinates to make a charitable contribution for a nonprofit. And so, a lot of times the people who are going to be having these big retirement parties are going to be office directors or fairly senior people. And so if you have an office director who is saying, at my retirement party, in lieu of a gift, please donate to this charity, then in addition to potentially violating the OPM solicitation rule, you're also going to be violating potentially the OGE fundraising rule, because you're going to be soliciting for a nonprofit from a subordinate, which you're not allowed to do under the OGE rule.
And then there's also, of course, the catch-all OGE provision about misuse of public office for private gain, and you could potentially argue that using your agency email to send out a solicitation, if you tell people, if anyone who comes to my party, please donate to this charity that I work with, that may be using your public resources and your public position to explicitly benefit some outside private organization. So there's lots of things that could cause problems here, but there is another argument you might face on the other side also from employees, because I think you might recognize that in the gifts between employees rule, there is of course an exception for gifts solicited for special and frequent occasions, and retirements are generally considered special and frequent occasions. And then if you look under the definition of gift, in gifts in 5 CFR 2635.203 F2, you can see that a gift for an employee may include a gift given to some other organization or other person on the suggestion of the employee. And if this is a special occasion, like a retirement, you may end up in a situation where you are forced between these different authorities, and you may conclude that this is an acceptable gift under that provision, or the special and infrequent occasion exception. But there's sort of conflicting authorities here, so you really want to be careful and think this through when you come across these situations.
Right, because these people can definitely get very feisty when it comes to their retirement parties, and if you're saying, no, you're not going to be allowed to, make a donation to the American Cancer Society, people might not like that, and they might start questioning your advice and then asking you to really pinpoint what the actual rule, what the source of that prohibition is. And so it is important to keep all of these in mind. Another area where people can can raise sort of similar type issues would be obituary notices that sometimes you'll see come across emails at agencies. And
I think a lot of times, at least at the agencies I've been at, I know longtime employees who've left recently, or even current employees when they pass away unexpectedly, or everyone knows they've been battling an illness, and then all of a sudden they pass away, and then you have employees who want to know about it, and then some other employees will suggest circulating their obituary. And many of these obituaries will ask for donations to, for example, the American Cancer Society, or in some cases they may even ask for contributions to political candidates, which we've seen actually in the news a couple years ago, which of course raises its own Hatch Act issues. Of course, soliciting for political campaigns is a definite problem. But these can be very awkward because just like soliciting for gifts for your retirement party, people get very touchy about any suggestions that maybe you shouldn't circulate an obituary. So you just want to think about the rules and think about who is actually doing this listing in this case. You know, if you're just forwarding an obituary from a newspaper, are you really soliciting for are you really speaking for everything that's in the newspaper article, or is this maybe something that's okay? But there are questions that come up to agency ethics officials about this sometimes. So
yeah, this is also one of those things where it's sort of difficult for a lot of the agency ethics officials to police, because you're only going to hear about it if somebody, I guess, gets offended by the obituary notice or thinks that there's a problem. And so if no one is kind of taking offense to what's in the obituary notice, something like this is probably never going to get brought to the attention of the actual agency ethics official.
Right.
And this next example, changing gears a little bit, is an example of something that was only brought to attention because of sort of annoyance and anger amongst different federal employees. So this is based on a real-life example, and what happened here is that you had a federal employee who wanted to solicit funds for his daughter's beauty pageant. The way this beauty pageant worked is that in order to attend, or as a prerequisite of attending, you had to solicit travel money so that you could pay for the hotel and pay for some of the transportation costs. And so this employee put a flyer, stuck the flyer to his office saying, basically, please contribute so that my daughter can attend this beauty pageant. Other employees found out about this walking by this person's office and then said, this doesn't seem right, this can't be allowed, can you please talk to this employee and tell him that this is not permissible. So then I started looking into the different rules and the different regulations that would apply here, and what I ended up finding is that this is one of those questions that kind of neatly skirted every single regulation, where it fell through the cracks of all of them.
Right. You've got a lot of regulations that could maybe apply that you'd think of looking at in these situations, but for example, if you look at the CFC rules about solicitations, but remember, the CFC rules in 5 CFR Part 950 only cover charitable solicitations, and this isn't a charity. This is clear to benefit the employee and the employee's daughter, so that's not going to that regulation doesn't prohibit the solicitation in this situation. Also, the OGE fundraising rule applies to fundraising for nonprofits. Well, again, this isn't a nonprofit endeavor. I don't know what prize. Maybe you get a special tiara at the end or something, but there's no nonprofit involved here, so the OGE rule doesn't really come in. Then you have to look at the GSA property regulations that talk about solicitations. Well, those cover, first of all, commercial solicitations, which I don't think this is really a commercial solicitation. This is a personal solicitation. It's not advertising a business or anything like that. And the GSA rules cover soliciting for alms, which isn't defined in the regulations, but I think just common usage means it's really charity for the needy, for the poor. And this isn't, the employee obviously doesn't have as much money as they want to fund their daughter's pageant, but I don't really think this counts as solicitation for alms. So this is probably okay under the GSA rules, or at least not explicitly prohibited. So then you look at the rule for gifts between employees.
Right, and the problem with the rule on the gifts between employees is it does prohibit employees who are making more money than another employee. It prohibits that employee from accepting a gift, but it doesn't prohibit solicitation of a gift. And so there's a disconnect there where you can't take any disciplinary action against an employee who is soliciting from an employee who makes less money than they are. It would only be if the employee actually accepts.
And don't blame OGE for that either. That's in the statute. That's as far as they can go.
So the reason why there is that disconnect is because the statute, I think, is limited to solicitation. OGE also has their catch-all regulation, the one that Sean was talking about earlier, the misuse of public office for private gain. That one actually might have been the best fit or the closest fit here, because you could easily say that what this employee was trying to do is use her position at the agency to benefit her daughter by allowing her daughter to attend this beauty pageant via raising money. But perhaps different agencies would have more specific regulations that would catch this kind of solicitation, because the generic ones that apply to every agency wouldn't really seem to fit. So this would be a good example of maybe why an agency would want more specific restrictions and regulations on this type of activity, so that nothing would fall through that net, and then you wouldn't end up having employees calling the agency ethics officials distraught because of these solicitations going on. Kind of a postscript to this, what ended up happening with the employee is that, basically once the employee found out that other employees thought that this was a little bit unseemly, the employee agreed to voluntarily stop the solicitation. And so this is a good example where even if you can't actually point to a regulation, appearances do matter, and if there is an appearance on other employees that this employee is acting unfairly or trying to glean some unfair advantage, most employees are going to be pretty receptive to that, and you're going to be able to resolve the problem without having to point to a specific regulation about what they're doing that would be wrong.
Though we actually have a list, if you look at the other PowerPoint slides that came attached, there's a few agencies like DOD, GSA, and so forth that have regulations. I think Postal Service and HHS also have regulations that prohibit employees from soliciting other employees in certain cases, especially employees who work for them. And so they kind of cover over some of these gaps that might be in the OGE rules or in the other regulations. So maybe a good idea, something to think about going forward at least, or internal policies also, because not every agency internal rule is listed in the CFR, so your agency may have some unpublished policy or directive that limits employees from soliciting other employees and selling things to them and so forth within the agency. Again, it's just something to think about when you're working with these situations, because the misuse of public office regulation it's broad, which is a good thing because it covers lots of conduct potentially, but it's also vague. So you can face challenges from your employees if you say this is a misuse of public office and it's not totally clear, it's not specifically prohibited in the regulation, so that you may face more challenges, and it might be easier if you had some more specific authority you could point to in those type of cases. So
another scenario that comes up frequently would be what we termed, or we would call, professional organizations. And here, we'll use the ABA as an example. The ABA sends out routine emails about updates about what's going on, etc. And it seems like every office kind of has one employee whose job it is to forward that to everybody else, even if no one else really wants to read them. Occasionally, though, what you'll see then is there'll be an announcement for an upcoming meeting that the ABA is hosting, maybe even a more specific meeting, like an ABA environmental law section meeting. And then that employee will forward that to other employees in his or her group. And then that raises ethical questions, are basically like, are you impermissibly promoting the ABA while you're at work?
Right, and in this case, there's actually some OGE advisory opinions that can be helpful, and we've cited those in the other handout if you want to take a look at them and pull them up on OGE's website. I think the basic gist of them is that under the misuse of public office regulations that talk about endorsement of organizations and so forth with agency resources, the general idea is that it may be okay to use government resources in connection with promoting some outside event that's related to the agency, that's connected to the agency's mission. So for example, your agency may be co-sponsoring the event or something like that. In that case, it's probably okay to announce the meeting internally, or if it's maybe a year in review of the agency's actions, and with some big agencies you'll see that, maybe it's a little better in that case, but it's a little more ideal, I think, if there's some sort of non-disclaimer notice also attached to these emails. If you want to advertise some outside event, maybe make it clear that you're not personally suggesting everybody do this, or the agency's not endorsing it and so forth.
Right, and where the endorsement issue can really come into play would be if someone is sending around email from ABA, which is encouraging other employees to actually sign up for the ABA and become a member of the ABA, because there you really, the nexus between the agency's mission and then becoming an ABA member is not as clear as in the example that Sean was just talking about, and then you would also run into potential endorsement issues. If you're an employee and you're sending around an email to other employees saying, look, the ABA is a great organization, I think you should all sign up and start paying dues, well, then you could very reasonably be viewed to be as endorsing the ABA, which you shouldn't be doing while you're on official time.
Or you could also be viewed as advertising for
Right.
this organization. And if you look at some of the other sources that are cited in our attached handout, there are rules about commercial advertising in particular, which may come up in certain cases if some of these are for-profit groups that people are involved in. There's a GAO, just general appropriations law rule, that says that agencies should not use appropriated funds to get involved in commercial advertisements. And then there's probably the most obscure rule of all. There's a congressional printing and binding regulation from 1990 that's still valid, that says that agencies should not use any government money. So this is appropriated or non-appropriated if you're in a lucky non-appropriated funds agency. And it says that you cannot use government money to advertise for any other like commercial activity or commercial organization. So just think about that if it looks like someone wants to suggest that people go to their yoga instructor or something like that. That's a commercial activity, and however wonderful this yoga instructor might be, you can't use your government resources to advertise for them effectively. But we were giving this presentation last week before a different audience, and a question came up about Toastmasters. So that raises some difficult questions also.
Right, because a lot of agencies do have Toastmasters clubs at their agency, and Toastmasters, for those who aren't aware, is a public speaking type organization that promotes public speaking, and they hold meetings usually around lunchtime where then people would go up and give a toast or a speech. And some agencies, it sounded like, had official arrangements almost with Toastmasters, others didn't, and so this would be something where you would really need to look at the facts, see what was actually going on before determining whether you're able to send around emails to other employees encouraging them to sign up for Toastmasters or join Toastmasters.
Right, because Toastmasters is an outside organization. They are their own separate thing. If your agency has an official arrangement where it sponsors a Toastmasters group or something like that, it might be a little better. Although agencies, of course, have to be careful about endorsing outside organizations. But if it's just a group of employees who band together on their own and say, hey, let's start a Toastmasters chapter at our local lunchtime, meet at agency headquarters in this conference room or something, you may face a few questions from other people about why they can't endorse their own outside organization that they're involved in. And so that's going to be something that you might want to think about going forward.
So Sean had briefly mentioned the GAO rule on commercial advertising, which is a rule that I would never have thought would have any real implication in the ethics world because it's a rule that applies to appropriations. We reference that rule in the other slide deck, but to give just a very brief overview of that rule, basically it prohibits agencies from using appropriated money to support any kind of commercial advertising. A scenario where this may be implicated would be what we would term affinity group type scenarios. So here you have, let's say, a group of Arctic employees from the agency who want to band together and form their own group. That's totally permissible under various federal policies. They're allowed to do that. Where the scenario can get a little bit dicey, though, is a lot of times these groups will say, we're going to have our first meeting at the restaurant right next to the agency. And so then you get into the question of if they start sending around emails to the members of that group and they start saying phrases like, we're going to go to this great restaurant right next to the agency or this delicious restaurant right next to the agency. Are they crossing the line into impermissible commercial advertising on behalf of that restaurant? It might be best if they just say, we're going to go meet at this restaurant, as opposed to inserting adjectives and modifiers like great, delicious, inexpensive, the best restaurant in town. And there's
right, and sometimes you may face questions also about, of course, endorsing them. Is this, and if it's not an advertisement, at least are you endorsing them by suggesting that they're wonderful? It's sort of a connected question. If you're using agency emails, though, to go ahead and email other employees saying you're going to meet at some outside organization, you're going to a Washington Nationals game afterwards or something, go Nats maybe, but okay, but then you start saying more things like how wonderful the baseball team is. Well, that's a commercial organization. They're in their business. So at that point, you start looking like, I mean, some people might raise questions, maybe fans of other teams who would question you and say maybe you shouldn't be endorsing some business, sports business or a restaurant or meeting at some other outside venue. And you can see, obviously, that raises some ethics questions.
And if that's sort of a gray area, I think that everyone would agree that where it really crosses the line would be if you want to send around an email saying, we're going to have our first meeting at this great restaurant across the street, and by the way, here's a $5 off coupon to this restaurant that you can use at that meeting or for future use. Because then you really are just providing commercial advertising to that restaurant with no clear benefit or any benefit to the actual agency itself. So I would recommend employees that they should be very wary about sending around coupons to restaurants or places nearby. I know that that can be sort of common. If there's a restaurant that opens right next to an agency, they might try to have a big promotion going on, and they might try to get some agency employees to get the word out, but you don't want to be doing that because you would be running afoul of this GAA rule that you're not supposed to be using any kind of appropriated funds or your government position for commercial advertising.
Yeah, in my experience, this does come up again and again because businesses like to open next door to government agencies. That's a source of a lot of potential customers, especially restaurants. And so you'll see some very aggressive marketing efforts on their behalf, and they'll send emails they'll find out who the person is who runs your agency's internal newsletter for employees, and they'll email them and ask if they could insert a message announcing the opening of this restaurant, or like Jeremy mentioned, or in the scenario, a $5 off coupon for agency employees. Just show your agency ID. Of course, that raises potential gifts questions also. So there's all sorts of things you want to keep in mind. But this does come up again and again, believe it or not. And you also have just employees sometimes. Sometimes this has nothing to do with the restaurant itself, but there will be employees who are very excited about some business they go to. Like, my yoga instructor is wonderful. Everyone should know about it. And they'll want to place an advertisement in the newsletter saying, look, this yoga instructor is open for business. They're looking for customers. They're wonderful with people from our agency. They're right across the street. And when you get involved in that, it leads all sorts of endorsement and advertising and gifts questions, and you definitely want to nix that and nip it in the bud. So be very careful.
And so one more scenario that we'll be discussing involves housing ads, and the statute involved here would be the Fair Housing Act.
Yes.
Which is, once again, not a statute that you would normally associate with ethics regulations or ethics laws, but we will be explaining why it does. So the GSA rules that prohibit commercial activities in the building do have an exception for what they would call, or I guess what I would call kind of the bulletin board exception, where agencies can allow their employees to engage in minimal advertising on a defined bulletin board. So they can't advertise in the lobby or in kind of very big shared spaces, but if there's a special bulletin board, they can advertise on there. In my experience, I saw a lot of times on these bulletin boards, you'll see housing ads, because you have landlords that are trying to maybe rent out an apartment, and so they'll put a notice on the bulletin board saying, do you know of anyone who is looking to rent in this place? You can also see people who are looking for a roommate. In addition to going on Craigslist, maybe they'll just try the agency bulletin board, and once again, they'll say, do you know of anyone who wants to live in this area? Please contact me. So you wouldn't think that this could raise any kind of ethical problems. The GSA does allow for commercial advertising, and all they're doing is just trying to either rent out an apartment that they own or find a roommate. But there can be potential restrictions and problems here if they go about this the wrong way.
Right. So first of all, just remember, Jeremy mentioned the GSA rules. They say that agencies can allow concessions or personal notices posted by employees on authorized bulletin boards. Well, remember, that means authorized bulletin boards, so the agency has to actually set aside a space. It doesn't have to set aside a space. If the agency wants to avoid these questions, it can just say, sorry, we don't allow that here. We don't want to get mixed up in these questions. But I think in practice, many agencies do have bulletin boards. I think increasingly these are virtual bulletin boards. So you'll see an internet page just set up for like personal classified ads. And people will post housing ads, or they've got a timeshare that they're trying to sell or something like that. And unfortunately, however, many employees on these personal housing ads will include all sorts of wish lists of things they're looking for. Like you can see in our example, we have employees who is searching for a quiet, single, non-smoking, professional, orthodox female tenant. And yes, we have seen things like that. You'll see them on Craigslist too occasionally. Other times they'll say no pets or something like that. Well, the problem here is that we have the Federal Fair Housing Act, which you would not think of as a source of an ethics rule, but it is. Or at least it's not an ethics rule, but it's a serious federal law that still will apply in your situation, because the Fair Housing Act says that you cannot discriminate in housing advertisements. You can't post them, which applies to the agencies, but you also can't be issuing them for the employees themselves. So the Fair Housing Act sets aside a number of protected categories. For example, you can't say you only want people of a certain age or gender or religion. It's not a laundry list. It's not a very long list, but you still need to take a look at it, because sometimes employees will post, for example, that they want a female tenant to take over, because they'll say women are less messy, which may or not be true. So they'll see these type of these ads, and employees will never think to talk to the ethics official. So this is something where some advance notice may be good. But there is, however, another issue that can come into play with roommate ads.
Right, so we have to draw a distinction between someone who's trying to rent out an apartment and find a tenant and someone who is just seeking a roommate, because there are cases out there, particularly a Ninth Circuit case, that says when you're trying to find a roommate, you can be a little bit more precise in who you're looking for with the ad. So you actually can say, if you're a female, you can say, I'm seeking a female roommate. And so you can give a little bit more leeway when you're trying to find a roommate. And the idea there is because it's a shared living space, you're letting that person into your home, and so you can be a bit more specific in what you're looking for. If you're just finding, though, a tenant to actually live in there, you're not going to be able to be as specific and precise. And the other thing that we should add is, we just been discussing the Fair Housing Act, but different jurisdictions may have even more specific restrictions than just the Fair Housing Act. So, for instance, D.C. may have a restriction that you can't discriminate based on political status or something like that.
Yes, it does.
So you can't say seeking a Democrat to rent out my apartment. And so it's not just the statuses that Sean was talking about in the Fair Housing Act. You also want to make sure that you're not violating, if your apartment is in Washington, D.C., you want to make sure that you wouldn't be violating any D.C. housing acts as well.
Right, and the D.C. law is particularly broad, so we just mentioned that briefly. But, for example, under the Federal Fair Housing Act, you can say that you're looking for a professional roommate or professional tenant. But under the D.C. rule, it says that you cannot discriminate based on source of income. So that could get you into trouble if you're advertising in D.C. So just keep that in mind when you have employees who post these things, because nobody thinks that their personal classified ad is going to raise either ethics issues, first of all, but also Fair Housing Act. Not many ethics attorneys would think to look at the Fair Housing Act, but it is enforced. HUD actually is the agency responsible for enforcing the Federal Fair Housing Act, and they do go out and conduct enforcement actions. So it's something you want to be. You don't want to run into this issue with your agency. I've dealt with it several times actually, and of course this raises questions of who's going to police these bulletin boards. And I think in my experience, often it's the agency ethics officials who end up walking by them and they see a discriminatory housing ad and they have to figure out what to do. And or people will come to the ethics officer and say, look, I saw this on the bulletin board. Isn't this illegal somehow? Because somebody gets offended. And this may be a reason why you would want to think about what you're doing as an agency, because remember the GSA rule says it only applies, people can only post these classified notices on bulletin boards authorized by the agency. So do you want to authorize them? I mean, we can't, not really saying one way or the other, but it's something you want to think about when you're in these situations. So
yeah, if your agency is getting a lot of complaints from people who are saying, I really don't like walking by and seeing people trying to sell their car, people trying to rent their apartment, people trying to sell me an old computer, then it may make sense for that agency just to then prohibit their employees from engaging in this kind of commercial activity.
And these bulletin boards can also raise other commercial advertising things, because sometimes people, like I mentioned earlier, they want to advertise their favorite yoga instructor. Well, that's not really a personal classified ad. You're just advertising for a business, and I don't think that's allowed under the GSA rules or under the GAO rules, or the if you're using agency resources to basically advertise these people. Definitely not on an internet bulletin board. You know, that's going to be a problem too. So you'd be surprised how many issues can come up, ethics questions from these bulletin boards. They're a real source of work for agency ethics employees. So just keep that in mind. Okay, well, I think that wraps up what we had for our slides here.
Okay, well then, why don't we, Kevin, if we could open up the phone lines for any questions if people have on the phone lines, and if you're on the Google Hangout, You can also post your questions on the Hangout.
Absolutely. At this time, if you would like to ask any questions, please press star, then 1 on your touch-tone phone. Questions will be answered in the order in which they are received. Please be sure to state your name after the prompt so we can announce your name prior to you asking your question. Again, please press star, then 1 on your touch-tone phone if you have any questions. One moment for the first question, please. And your first question comes from Troy Byers. Your line is open.
Hi. With respect to the housing rules, is with the DC example, is that only if the place that you're planning to rent out is in DC? So if your house or whatever you're renting out is in Virginia, do you have to abide by the DC rules even though the residence isn't there?
Well, I'm not a DC barred attorney, so I don't want to profess to be an expert on the DC rules, but I think you want to take a look at the DC Housing Act, to actually look at the law and look at your situation, and there may be some sort of immunity questions if you're a federal actor and things like that. But these are roads that can be difficult to go down, so you might want to look also at the Virginia law in your case and think about, it's at least something that you can raise with your employees and say, look, this could be a problem. Even if there's a technical argument against it, it's a reason for employees to be very careful. So,
Roger that.
Thank you. And your next question from Jessica Shaw Nelson. Your line is open.
Hi, I'm with CBP, and I have a question about a request that we recently received. We have a group of employees who, they have a holiday party every year, and they would like to do fundraising activities on official time in the office to help defray the cost for their holiday party. And we realize this engages a number of different regulations, but we've been pondering it over here. We haven't ever addressed this issue before, and we'd be interested in your thoughts.
Well, yeah, that does raise a variety of questions. I guess I'll take the OGE rule, and then maybe Sean can discuss the OPM part of this.
Sure.
So the OGE rule on personal fundraising for this probably wouldn't apply, I would think, because that rule is limited to fundraising for nonprofits. And so if this group is just fundraising to defray the costs of an annual dinner or something like that, unless they've organized their dinner in such that the dinner is a nonprofit, I don't think you would get into issues about raising money from subordinates and then the OGE fundraising rules.
right, I don't think the CFC rule would really apply, and I'm not sure that the GSA rule about commercial solicitations and solicitations for alms, that doesn't really apply either. But you still got definite questions about maybe fundraising from subordinates. I mean, I'm not sure who the employees in question here are. And then there's questions, of course, about just coercive activity in the workplace. If, for example, with holiday parties, sometimes people feel compelled to make a list of who's donating and who's not and posting that, and that's a nightmare from HR perspective. But I think you definitely want to take a look at it. But it can cause some problems under these sort of personal solicitations, because it's similar to the beauty pageant example, right, where it's not really clear sometimes which rule can apply. And if you're using public office to, for private gain, and there's questions along those lines. But this may be another reason in some cases why you want to look at an agency-specific rule in some cases to cover some of these situations where it's not totally clear which rule applies.
And I would think that it would be particularly unseemly if this group that gets together each year and has a dinner is then fundraising or soliciting from employees who wouldn't be invited to that dinner or going to that or part of that group. To the extent that this kind of fundraising would be permissible, I would think that it would only be fundraising within that individual group. It wouldn't be just fundraising the entire agency.
I think holiday parties are just a wonderful example of things that create full employment for ethics attorneys, though. It's never-ending source of joy for us and lots of fun questions. So I feel your pain with that one.
Thank you. And your next question comes from Arthur Adams. Your line is open.
Thank you. This is Art Adams with ICE. I just wanted to contribute on that. There's a possibility with CBP that this could be a legacy morale, welfare, and recreation organization from back when the Border Patrol was part of INS. And I really don't know whether or not those are nonprofits. It's possible they might be. There were some old internal rules that allowed the establishment of that. So I just toss that out there. It's maybe another factor. May not give us any more clarity, though.
Thanks. That's helpful. That's something to think about.
Yeah, because one of the things that, this is Cheryl, one of the things that Sean and Jeremy had talked about a little bit ago is OPM has a panoply of sort of exceptions for fundraising provisions for employee benefit groups for the welfare of their own employees. So depending upon this, whether or not this is one of those employee benefit groups and whether or not arguably they're raising those funds for the benefit of their own employees, but it has to be among their own employees. So you really want to take a look closely at the OPM provisions because they do have some carve-outs that are kind of very specific and actually kind of squirrely.
Thank you. Again, if you would like to ask any questions, please press star, then 1 on your touch-tone phone. One moment for the next question, please. At this time, I am showing no questions. Again, if you would like to ask a question, press star, then 1 on your touch-tone phone.
Gentlemen, hi everyone, this is Ryan Segrist. We have a couple of questions here on the Hangout, and I'm going to try and translate one of them. The other one, actually I'm going to ask the one that is clear first. This is from Joseph Terrell. He is asking on the alms issue. Is there really a difference between a rich individual asking for a personal donation compared to a charity asking for donations to the poor under the GSA section?
Well, the GSA rules are unfortunately a little vague about what exactly alms is. I mean, I just looked up a dictionary definition of alms because when I first encountered this, I thought it wasn't really clear, and I think that's a fair question perhaps about what that means when they're... I'm not sure, I'm not aware of any GSA advisory opinions about this section. Well, I'm aware of the child care legal opinions, but this about the meaning of this particular provision about what it means to solicit alms is really, as far as I'm concerned, it's something of an open question and something you may want to talk to GSA's lawyers about.
And the next question that we have on the Hangout is, I think what this person is asking is if there is a general prohibition of doing any sort of fundraising on their own time during the CFC.
There's no prohibition on doing fundraising during the CFC. There could be prohibitions on doing political fundraising due to the Hatch Act, and those restrictions would be you can't host a fundraiser and you can't ask other employees to solicit on behalf of a preferred candidate. But in terms of fundraising for just general nonprofits, charitable organizations, or even commercial organizations, if you do it on your own time away from the government, then there's no ethical problems, even if it's during the CFC.
Just remember not to use your agency title and resources, so don't send out fundraising solicitations from your agency email account. Don't use your BlackBerry to do fundraising. Even if it's after work hours, you're still using agency resources.
Don't use your title.
Yes, don't say, I'm here calling from the Federal Reserve Board and I'd like to get your donations, especially if it's an organization that's, if you're working on JP Morgan matters and you're hitting up the JP Morgan Foundation after work, you can see why that could potentially cause some problems. So you want to be very careful about those limits, which are set forth in the OGE rules. So.
Great, thank you, gentlemen. We're not showing any other questions on the Hangout at this time.
Do we have any more? Kevin, do we have any more on the phone?
I am showing no questions on the phones.
Okay, I have a couple of questions for you guys. One is, how do you guys handle complaints? You said that a lot of times the way that these things come to light, Certainly by policing bulletin boards, that might be one way that's happening, but it clearly, obviously, you got people coming to you complaining about these things. Kind of what is your process, or how do you guys approach this when somebody comes to you with a complaint? What follows thereafter?
I can speak to the NRC. Fortunately or unfortunately, we're in sort of a reactive mode because it's difficult to police a lot of these things. Particularly, examples would be obituary emails that come in. We're not going to hear about that unless we're part of that original email or if an employee starts to complain. So the process at the NRC would be if somebody is engaged in personal outside activities at work and it's bothering another employee, they're likely to contact the agency ethics officials and say, hey, this person's doing this. I don't really know if this is allowed. Can you please look into this? And then if it's not allowed, tell that employee to stop. And then once we get that information, we'll do a little bit of our own investigation. We'll talk to the employee and then try to reach sort of an agreement where they will stop. And if it's one of those scenarios like the beauty pageant scenario where it doesn't really fit a specific ethics restriction or regulation, then we'll just rely on you're annoying other people at work. It might not be a good idea from your long-term career standpoints to be annoying people. So even though we can't pinpoint a specific ethical restriction, it still might be a good idea to stop just as a kind of general principle.
Yeah, it's like the social pariah.
Right,
yeah,
exactly.
Okay. I think you want to sometimes these things come in through the HR, Human Capital Office. They are the source of hearing a lot of employee grievances also, or your EEO office or something like that. So you may end up coordinating with them to handle these disputes between employees. I think they're often a source, and they will contact personnel attorneys in your office and work with ethics attorneys, and it's good to be able to have that teamwork. So.
But I would say a lot of these things probably do slide under the radar because if no one complains about it, you're never going to hear about it. And so I'm sure that the scenarios we discussed, I'm sure violations of these take place every single day at agencies and just no one gets offended by it or no one cares. So it's hard to think of a way that you can be proactive because that would mean you'd have to be on sort of the distribution list for every single retirement party that's taking place at the agency, for every single obituary notice that is coming through the agency. You'd have to be policing the bulletin boards on a semi-regular basis. You'd have to be involved anytime someone wants to do any kind of fundraising, and so I don't see a lot of agency ethics officials volunteering for that kind of micromanagement and being involved in every single decision.
But there's always training. I mean, in initial ethics training, I try to cover some of these things, but you have your orientation for your new employees. So when you talk about the OGE misuse of public office rules and things like that, you can mention a few of these restrictions just to give people an idea that there are some rules that govern your personal activities too at work. So.
And then I just have one final question for you, and that's, do either of your agencies, or do both of your agencies have limited personal use policies? And if so, are they helpful in this area, and do you have any thoughts on whether or not you could nip some of these things in the bud or deal with some of them through limited use policies? I'm curious.
Are you talking about technology, like a de minimis personal use of your
anything, of your .gov emails,
Yeah.
of your computers, of your time, space, government space?
I think we have, and I think most agencies have, sort of a broad general policy about de minimis personal use of your agency computer, your email account, and things like that. And I think there's also some restrictions on, for example, streaming video and big IT tech burdens, but I'm not personally aware of any particular really focused rules about, you might want to coordinate with your IT folks, for example, but there are bulletin board rules in some agencies. Like I know the NRC has this rule about which bulletin boards you can use and that sort of thing, and where you can't do things, but I'm not aware of really specific policies about this.
I'm not aware either. It also seemed to me like if someone is just doing a limited use type thing with this stuff, you're never going to probably hear about it because they're not going to be ticking off other employees. Mm-hmm. So it sort of polices itself. If employees, their personal outside activities to the de minimis level while they're at work, you'd have to probably have a very sensitive coworker who would ever think of bringing that to the agency ethics official. It's only when that person, stacks on a flyer to their door saying, please donate to this, or sends out a mass email to 100 people saying, please join this organization, that you're going to start seeing these questions trickle in.
Right.
Well, I think that we've exhausted our questions from the audience, and I've certainly exhausted my questions. Sean and Jeremy, we cannot thank you enough for coming in today and providing us with this information. I think these are thorny problems that every ethics official faces sooner or later, and I think you've really helped to direct people to the various authorities that they should be becoming more aware of, and when they're having to analyze these situations, so that they can sort of root through and figure out what's ethics, what isn't, and be able to provide a really robust answer to people who are asking these questions. So thank you both very, very much for your time. And for those of you who are on the Hangout and on the phone, thanks again for joining us today. And as we said, we'll be back with you next Thursday to do our IEG year in review and look ahead. And we look forward to seeing you or hearing you, having you hear us then.
Thank you. This ends